Hello everybody and welcome to today's episode of Activist Lawyer. I am very fortunate to be joined by Honza Cervenka, who is joining me from Zoom in London today, and he is a solicitor of England and Wales and is also a California attorney. He is recognised as a leading figure in the field of online reputation and privacy and is frequently asked to speak on the legal challenges facing victims of online harassment and image-based sexual abuse. Honza grew up in the Czech Republic, and as a teenager he was a frequent lecturer in computer science courses for the public at the Technical University of Ostrava. Due to his background in IT, he now works on the technical aspects of helping people whose reputations have been attacked online. At McAllister Olivarius, Honza works on a wide variety of cases on both sides of the Atlantic, including civil, employment and data protection litigation in the UK, and Title VII and Title IX discrimination cases in the US. He is also head of Queer Rights Lawyers, a practice dedicated to serving the LGBTQ+ community. Honza received his BA cum laude in music and international studies at McAllister College in Minnesota, USA. And while in Minnesota, Honza worked in the law offices of Jeff Anderson and Associates for 2 years, where he assisted in numerous lawsuits against child sex abusers. He completed his legal studies at the University of Law, Bloomsbury. Outside of office hours, he is an enthusiastic photographer, conductor and singer. So I'm really excited to have you join us today and discuss the really interesting work that you do, Honza. Just to get us started, I guess I'm interested in where it all began, and if you could maybe take our listeners back in time a little bit as to why, you decided to get into law, because you've got a very, extensive specialisation there in different aspects. What drew you to the legal world?
Yes, thank you. I did hop around a little bit before I landed in law. I took a bit of a strange journey, I suppose. I am originally from the Czech Republic and lived there throughout my childhood. When I was 16, I was fortunate enough to manage to get a scholarship to study at a United World College in Italy, which is an international school in Italy, and that kind of completely changed my life in, I think, making it international, which is something that I very much wanted to have, but also in making me think internationally and look at issues from a global perspective. That then, when I went to university, influenced the degrees that I chose, or at least one of them. I studied international studies to kind of, again, look at global conflicts and just the ways how present-day issues manifest themselves differently around the world. I also did a degree in music, and for a while I thought that would be my home. I wanted to become a conductor and a professional musician, but through internships at law firms during my studies, I thought, the law could be quite a fun place. I worked from the beginning at civil rights firms, McAllister Olivarius and Jeff Anderson's law firm in Minnesota. And I liked the way how they practiced law, in that sort of took the abstract notion of trying to help people, trying to make the world a better place, and made it a bit more practical, a bit more realistic. Sort of the idea that rather than having this sort of impact through academia, which was another career path that I considered. Both of my parents are teachers, so I think that was one of the reasons why I was drawn to it. I like the more focused aspect of civil litigation, where you're trying to make a bigger argument, trying to change the law, but ultimately the vehicle for that change are people. Something happened, it's this, and you're using a specific situation to shed light on a bigger problem. And ideally, you want to help the people, represent the clients, put them in a better place, give them a sense of justice. But also perhaps the organizations that were sued, or maybe even the society at large, uses that case to reflect change and make the world better for others. So I like that kind of cause and effect relationship. And so eventually, after I graduated from a university in America, came back to London as a paralegal to work at McAllister Olivarius. Eventually became a trainee, qualified, and a few years ago sat for the California bar and passed. Thank God, because it was a horrible experience. I'm glad that I got it on the first try. Excellent. I definitely was not looking forward to a repeat. And so now I'm able to represent clients both in England and Wales and in America, in California, which I personally like because it brings a lot of variety to my work, but also keeps the international angle alive.
Sure. Excellent. And McAllister Olivarius itself sounds like a fantastic place to work and very specific in the areas of practice. Can you tell us just a little bit more about the firm itself?
Yeah. So a lot of our work centers on representing victims of discrimination, be it, say, failure to promote women in the workplace compared to men, or sexual harassment, sexual assault. We also do child sex abuse cases. We're also quite active in trafficking cases. And a few years ago, or I should say actually throughout the history of the firm, as far as I know, we've been trying to stay apace with what discrimination meant at the time. Sure. So a few years ago, the dialogue really started encompassing what was then called revenge pornography. Now we're calling it image-based sexual abuse or intimate image abuse, which is a term that I prefer, and began to see that as both an offshoot of sexual harassment, but also overlap with privacy law and data protection. Of course, the GDPR that was passed a few years later entered the scene as well. And so being alive to how the way how people discriminate against each other and hurt each other evolves, and encompassing those new areas. And also, most recently, I've been pushing for the firm to represent more intentionally queer people and focus on discrimination against queer people just as much as we're focusing on discrimination against women or discrimination on the grounds of race and other forms of discrimination. And that's really the core of our practice, both in the UK and in the US, occasionally in other areas around the world too. We sort of go where the problem lies, and if it's within our powers to fix it, we try to.
Okay, and forgive me for not being a very technically minded person, and I'm aware of these new terms under which you're working. But do you notice, I mean, are there differences, and is it difficult, I suppose, to deal with the challenges around, let's say, for example, online harassment, intimate, the abuse aspects as well, between the US, the UK and any other countries? I mean, it must be difficult to get your head around the various pieces of legislation. How does that play out?
Yeah, absolutely. And that's one of the big problems that I have with the area and the way how we tackle the problem, because our approach has been, and by our approach, I mean the countries around the world, has been very fragmented. We're still sort of operating in this old world national law perspective, where each country passes its own laws, and that of course makes sense in many ways. But if you're trying to tackle a global problem, each country having its own specific laws, little differences here, little differences there, and tries to tackle a global problem, that's difficult. Yeah. One of the reasons why, if you think of international law, you think of shipping, you think of international human rights. There have been global areas of our lives that countries around the world have recognized. You know what? We really should just sit around a big table and figure out some sort of standards that we can all operate by to actually make this possible. We haven't done that yet. when it comes to the internet and the sort of specific problems that it brings. And so what's legal in one country isn't legal in another country, and that creates complications. It also creates impossible situations at times if, say, the perpetrator lives in a country where their conduct isn't illegal, but the victims live in a country where the conduct is illegal, but there aren't really any easy legal redresses in those situations. Because how can, say, a court in London criminalize conduct by somebody in, Ghana, who's never stepped foot in London? And it may be that in Ghana, the conduct isn't even illegal. And so there's a lot of harm that can happen that people can inflict on each other. And oftentimes, unfortunately, in circumstances that are kind of outside of the law. And it really matters, or rather, the problem with intimate image abuse has, I think, underlined the fact that we need to start talking in a much more harmonized way when it comes to what's acceptable and what isn't acceptable online. Because the difference between the perpetrator living down the street from you or on the other side of the planet from you can be stark.
Yeah. And I mean, apart from the legal technicalities there, I mean, that's a huge piece, I guess, that will take, years of kind of discussion and negotiation. I mean, are people reluctant to come forward around these crimes in the first place? What challenges might present for the victim? I mean, that in itself must be off-putting, the fact that there may not be an easy route to address matters legally. But in your experience, is it something that people are willing to come forward on? I'd imagine it's very difficult in the same way that any sexual abuse or domestic violence cases are. What's your experience been with victims?
Yeah, I would say that it's very difficult for many people to come forward. A lot of our sex lives are still source of shame that the society, puts on us. And so the idea that, or the worry that people's response is going to essentially amount to victim blaming is very real in many people's minds. And so that acts as a big deterrent, I think, to coming forward. And the barriers in the law that then, if you do come forward, end up often stopping victims from actually achieving justice are also significant. We know that in England and in other countries around the world, police forces are having really suboptimal, and that's a kind way to put it, track records when it comes to, say, prosecutions of rape. And that's not to say that rape is the same as online abuse. It's not that simple, but at least rape is an offense that we've recognized for a long time, and legal systems have had, especially in old countries like the UK, had a long time to think about how to handle them, reflect, change, improve, and so on and so forth. But in the case of online abuse and intimate image abuse, those are relatively new offenses, and so if the legal system is still not properly helping women who come forward with a rape accusation, the chances of that same system performing well when a person comes with a complaint of intimate image abuse are just so much lower. And I see time and time again clients or potential clients coming to the firm and saying that they tried to go to the police and it just didn't go anywhere. That's not to say that there aren't cases where the police helps. There certainly are. But I think the overwhelming sense is that it's not a very effective way to seek justice. And that's a huge problem because a lot of the laws that have been passed in this area are criminal laws. In England and Wales, the statute that was passed in 2017, or even the reformed statute that is going to hopefully become law through the passage of the online safety bill, it's criminal criminal statutes, and so the police are the gateway to justice. And if that gateway isn't open nearly as wide as it should be, then that really starts eroding the sense of justice that victims can achieve, and that absolutely acts as a detractor against coming forward.
Yeah. And aside, I mean, when you think about it, these are challenges, I suppose, in the global context that face victims and survivors of abuse, this type of abuse and all types of abuse. But I'm interested as well in your work and zooming in on a very particular environment. And it's because I had experience working within, this structure myself, and it's within third level education. And how there are huge problems around reporting incidents of rape and sexual abuse within the context of the third level setting around globally again. And I remember speaking to both students and staff and being absolutely shocked at the fact that there were no mechanisms in place to deal with this, and very often serious matters and serious incidents were swept under the rug. A lot of the time it was because, it would draw bad press, I guess, and unwanted attention to the various institutions. That was a long time ago, and I'm hoping things have moved on. But I know you've been working with students in particular around representations for those who have suffered harassment at many levels, but also those who haven't, but would like to know that there are structures in place to support them if they had. What's your experience been around that?
Just as difficult as the issues that we discussed earlier, to be honest. In my experience, so my experience is primarily in representing complainants against their university, and we usually get involved long after, say, the sexual assault happened, often long after the internal complaints process at the university has started, sometimes even concluded. And what we often deal with are not necessarily the claims that the complainant may have against the student who they alleged assaulted them, but against the university for the way how they handled their investigation. And there is, I would say, an expectation on students and parents, and just to a degree the society at large, that universities should have some sort of duty of care towards their students. That these are still young people. They're not employees. So sort of the body of law that we have that establishes the relationship between employer and employee and the sort of duty of care that happens there doesn't apply. But there is a sense that the university as an institution should take care of their students and protect them. On a legal, from a legal standpoint, that is nowhere near to being clearly established. And so what has happened until recently is that universities have adopted a complaints procedure. So if a student wants to complain against another student for, say, sexual assault or rape, there's a procedure to do that. But that procedure has, in many cases, been kind of borrowed from criminal law and focused a lot more on the rights of the accused person than the rights of the complainant. And the experience of a lot of students that I've worked with that have gone through this process has been very much, you make a complaint, and then the complaint takes on its own life. You're sort of removed from the process as a complainant. You don't really get to know the ins and outs of the process because the accused student's right to continue studying at the university is possibly in danger. And so the universities have been a lot more focused on tending to the accused student to make sure that the process is fair for them. And that, of course, is important. But if, as a result, the complainant is left in the dark often doesn't have updates about the investigation, doesn't have straightforward access to counseling, for example, or other measures that would make them feel protected while the investigation is ongoing.
Yeah.
That's deeply troubling.
It is.
It's oftentimes in the cases that I've been involved with where the students need to be separated. So for protection of the complainant, the university decides that the complainant and the accused person should not take the same classes or be present in the same buildings or in the same spaces at the same time, for example. That is something that is not always achieved. And when it is, though, oftentimes it's the victim that ends up having to not go to certain buildings or change classes. And that also, I think, is problematic because why is the victim having to change their schedule rather than the accused person, or perhaps why aren't both changing their schedules? Because we also know, statistically speaking, the majority of complainants of sexual assault are women, and the majority of people who are accused are men. That's not to say that that's what happens all the time, but that's the majority. And so the university policies often then enter a realm of discrimination, perhaps indirect discrimination, to look at, well, you've got all of these rules, and on some level it makes sense why they're set up the way that they are, but let's look at the effect that it has.
Sure.
That you've got all of these women victims who are, in fact, being harmed more, in some cases, by the complaint system than perhaps because of the incident that first led to the complaint. Yeah. That is not an uncommon feeling for student victims to have. So it's a difficult area. I think it's difficult for universities too, because I believe that many, if not all of them, are trying to do the right thing, trying to strike a balance, and they can at times find themselves in a quasi-judicial role without really having the resources and the full procedures and the experience of doing that. So everybody is in a tough spot on some level, but the victims who end up often being our clients tend to walk away from the process often in a worse shape than they were when they started it, and that's a problem.
Wow. Yeah. So lots, room for more robust, I suppose, processes in place and legislation around that. Apart from that aspect of your work, I know you've worked extensively on race discrimination cases as well as sex discrimination cases. Can you take us through some of your work on those areas?
Absolutely. So one of the cases that I was involved in was the case Mander v. Royal Borough of Windsor and Maidenhead, which was a case where our clients were of Sikh heritage, and they tried to adopt a child. And they went through their local authority to do that. But then we're told that although they would be suitable adoptive parents, they could not actually apply, and that white couples would be given priority because there were only white children available. And ultimately, they were told if they wanted to, they were told to consider adopting from India, which at which point they gave us a call to see what we can do, and we ended up suing the local authority for race discrimination, and we ended up going all the way to trial, and we won. It was an interesting case. Mm-hmm. It was early on. I actually started the case as a trainee, but by the time the trial happened, I had qualified, which tells you a bit about the slow passage of justice, I suppose. Absolutely. But it was an early lesson in really trusting the strength of the case and the initial assessment, because I think we as lawyers are often, of course, trying to be nuanced as evidence gets exchanged. Every case ends up getting on slightly thinner ice than it was in the beginning, because you just know a lot more about the other side's case as you go along. But it was kind of interesting that the case ended up going all the way to trial. I thought that it wouldn't, because just some of the statements that the local authority made seemed quite clearly to amount to treatment different based on our client's race. But it ended up going all the way to trial, and it sort of taught me this lesson of just trusting your instinct, trusting the case, because just because the other side is really disagreeing with you doesn't actually mean that there's validity in that. And of course, a lot of litigation is ultimately driven to a point of settlement. That's not necessarily a bad thing, but we're trying to, I think, make peace, not make peace with the other side, find some common ground. See, okay, can we settle this? Can we not drag this out all the way to trial? And so when it does, it's almost a little disconcerting that, oh gosh, how come we're going all the way to trial? How come we weren't able to settle this? Yeah. But that's not necessarily a bad thing, and sometimes how justice works, and actually a good idea too, because it's important for cases to not always settle, because if they do, then there go opportunities to refine the law and change it. Ultimately, a settlement is very rarely public, and certainly almost never something that you can truly rely on from a legal perspective. So actually having cases go to trial and having judgments that can clarify the law and move it forward is just as important.
And set important precedents, I guess. And on that point, not only are you involved, in your day-to-day case management and representing your clients, your expertise has allowed you to contribute, I guess, to changes within the law and changes within policy. What areas have you been able to impact so far?
A big area that I've been able to impact was the Law Commission's consultation on the offenses surrounding intimate image abuse that happened a few years ago. It concluded, I believe, in 2021 in the middle of pandemic, and I was very involved with that, trying to push them to make the legislation wider. For context, the non-consensual sharing of an intimate image in England and Wales has been illegal since 2015, but only in circumstances where the intent of the perpetrator was to cause the victim distress. That at the time seemed like a good idea, and I think in many cases it is a good idea, but there are many circumstances where the intent to cause distress isn't made out, but the damage is still very much real, and kind of almost cries for justice. And so for a long time we've been criticizing the law that actually doesn't go nearly as far as it should to properly protect people from having their intimate images shared without their consent. And so we advocated for a broader interpretation of the law. I also wanted the law to be a lot more explicitly protective of the queer community, particularly of trans people, because given, say, the definition of what an intimate area means, you can get really very technical and quite biological too. Chest area, female breast tissue. The law uses a lot of language that is biological, and makes sense on that level, but really starts to fall apart once you look at it from a more gender inclusive lens, which I think is important to do. And so also advocated for that. The Law Commission ended up coming up with, I thought, rather strong recommendations. And actually, it's nice that we're recording this now, because we're a few weeks away from the online safety bill having reached its final stage, awaiting royal assent, and some of the changes were implemented in it, which I was glad to see. Unfortunately, none of the trans inclusive language made it into the actual text of the bill.
Really?
Which I think is a shame. It's my take on it is that it's important, on the one hand, important to have general language in laws, particularly when they deal with the internet, which is changing at a rapid pace. You can't get too specific because you could write the law and talk a lot about Facebook and Instagram and TikTok, and in 5 or 10 years' time, nobody's going to use those, and everybody's going to use something completely different, and suddenly, actually, the application of the law could be hampered by the fact that it was just a little too specific to what was happening at the time. And we know how long it takes to pass laws. And so it's important that the laws are kind of general and sanitized so that they can be applied in future contexts, such as they may be. But that does come, I think, at the expense of properly extending and explicitly extending the laws to specific situations, such as the complications, or not complications, complexities surrounding what an intimate area may mean for a trans person, for what it may mean for a trans man versus a trans woman, and other complexities that kind of the lawmakers ultimately, I suppose, leave to the courts to expressly recognize. But who has the resources to take a case all the way to court? How long does that take? How well is a lesson going to be drawn from a court judgment as opposed to a law being passed? There's fine balancing between how specific to be in a statute, and I think the government could have done a better job at explicitly extending the law to more circumstances than it has. But I suppose the fight continues.
Yeah.
I'm sure there will be more consultations out there, and it's an issue that will keep on evolving.
Yeah, absolutely. And I know at the moment you have a current case that's ongoing around discrimination. I think it's a New York-based matter.
Yeah, that's right. I'm representing a group of ex-employees at a major hospital in New York who are suing for discrimination and retaliation and other causes of action. And it's an example of, I think, us trying to make sure that the conversation around what forms discrimination takes stays current, because too often I think the law tends to be a bit conservative. We're kind of focused on precedent, and precedent, of course, means decisions of the past. And so we kind of keep on looking back to try to find support for our arguments today, when I think it's just as important to be looking forward and looking at trends that are happening, and what I think was considered discrimination, say, in the 1970s, when in the US a lot of the federal laws were enacted, or even the 90s, and what's considered to be discrimination and harassment now is very different. For context, slightly left field, but until the mid-90s, I believe, in the UK, it was the law did not recognize that a man could rape his wife. It was just seen that rape cannot occur in the context of a marriage, because there's, I suppose, some sort of an unwritten agreed idea to have sex with each other. That seems completely archaic to us now in 2023. but seemed a good idea for a long time, for a long time. And so if some of these laws predate even this, what I would consider to be a sea change, their value, I think, does get eroded over time. And we need to make sure that we look at what forms of discrimination takes now. And so this case in New York, one of the questions it's asking is whether or not gaslighting can amount, in fact, to discrimination.
Oh.
And again, if you look at the statute, it doesn't say gaslighting in it anywhere.
No.
It doesn't say what forms discrimination takes. It just says discrimination on the basis of sex or race, etc. is not legal. And so I think it's important, part of my activism, to kind of try to see whether the definition of discrimination that we have now is actually still current, or whether the last time courts and by extension employees in the society at large have looked at the definition, it's actually changed. And it takes a new form now, and we need to recognize it so that people can be protected from the discrimination of today rather than the discrimination of 10 years ago.
Mm. And I mean, on that point around activism, and I guess you're heavily involved in shaping, the areas of law within which you work, both here and in the US. I'm interested in getting your opinion on and your thoughts on activism and the law, both in a kind of general context and in relation to your more specific work. I mean, do the two work together? We've had so many different answers on this question on the podcast, but I'm really interested in hearing your thoughts on that, activism and the law.
I think it's a really interesting question, and I think there is a tension there. Like I said, with the law being a bit more conservative, looking at precedent, it continuing things as they are, sort of maintaining the status quo, is seen as a good thing fundamentally, because it kind of means that we can trust the legal system and that we can conduct our lives knowing what the standards are, and that's important. But on the other hand, the kind of activism that I do is a lot more on the liberal end of the spectrum, perhaps with a little spice of disruption in it, and kind of expecting, actually, just because we've been doing something for a long time doesn't mean it's good to continue.
Yeah.
And so there is, I think, a little clash there between the law and activism. Not also to mention the fact that, of course, we as lawyers are heavily regulated. What we can do and cannot do can have all sorts of things, have all sorts of consequences. So I think that also kind of makes us a lot more comfortable to just deal with the narrow confines of our work and leave our work in the office, and then kind of keep our mouth shut a little bit just in case. Just in case. And that's also not ideal, I don't think. And so I think it's important to kind of be mindful of that tension and see whether there's any flex in it. And like I said, keep on looking forward and envision or advocate for a change where the law needs it. And I think there are a lot of areas of the law that need change.
Yeah, and I mean, you just touched on a few, within your area of work. And I'm sure there's listeners here who will be wanting to know, more about your work, but also how they might become involved in it. And I mean, would you recommend it? I could see that you're very passionate about your work, and it's fantastic that not only are you representing clients and, working on civil litigation cases, which are ultimately to, get some form of compensation, for the client and for the victim, but there's so much more behind the scenes, and you seem to be working on, within work and outside of work, really progressing law and policy that will make effective change within our society. And so what tips or, advice would you have for anybody who would like to get into your specific area of practice? And then, one question that comes up for us is people who are about to graduate or are thinking about getting into law, and they'll say, I want to be an activist lawyer. And that seems to be a term that we're hearing a lot more frequently, which is good, as long as it's not coming from the government, obviously. But, people are really wondering, how can we get into this area? So I'd love to hear your thoughts. Happy to share my thoughts. I think it's a great area of the law.
it for people who are considering sort of other forms of activism, or just sort of bringing about change. So if people are torn between maybe becoming an academic, maybe going into the NGO sphere, I think sort of my little corner of the law is a good mix of all of that. Mm-hmm. What I wish I had known earlier about the kind of work that I do is that the law is only one piece of the puzzle at the end of the day, and actually on a day-to-day basis, non-legal skills are just as important as the legal skills. A lot of the clients that I represent are clients who've been through trauma, mm-hmm. and that can surface in different ways. Sometimes it doesn't at all. Sometimes in every client conversation, it surfaces. And actually, the amount of intentional communication that requires is quite high. And it's not something that they necessarily teach you in law school, mm-hmm. Or certainly in English law school. But it's just so important, knowing how to not only actually practice as a lawyer, but explain what you're doing to the client, who are often, in my area, lay people, perhaps, or hopefully this may be the only time they ever speak to a lawyer or litigate, people who never thought that they would be litigating. And so the law can be quite a scary thing and a complex thing. It takes a long time. Why does it take a long time? I wish I had a good answer to that question. But there's just a lot outside of the textbook that the work requires, and I find that really exciting. I have a huge deal of admiration and respect for the clients that I work with. It takes a tremendous amount of courage to stand up and file a lawsuit based on discrimination or harassment. And so I'm always humbled by I'm humbled by that, but also reminded of just how much of a switch it sometimes requires from being a lawyer to actually just being a person, and explaining to the client on the other end of the phone line not just the law, but also what it means in practice, and kind of helping them gauge whether a particular development is a good one, bad one, important, not so important. There are a lot of things that when lawyers talk to each other, they don't need to spend too much time on, because they kind of know the context. People in the street don't necessarily do, and they shouldn't, because it's not everybody needs to know everything about how the law works. That's what lawyers are here for. Yeah. But explaining it and properly representing them to make sure that they can actually, and building that trust really with the client, because my type of work requires, or I can only do as good of a job as I can if I know everything that happened. Yeah. And knowing everything that happened about sexual assault, rape, or even gaslighting or a privacy breach is just difficult. People don't tend to share all of those details with the first person they meet, and so it's important to build that rapport. And that's a very important set of skills that isn't picked up in a law school, and is just so important.
And just a final add-on kind of question to that. You're obviously a very creative person, so your work, I mean, that work that you've described, and anyone can only listen to see how demanding it is and how fast changing the law within your area is as well. Does your music and your interests outside of work, I know you're a singer as well, does that help you switch off, or does it help you kind of, just relax, I suppose, and make your work easier?
Yeah, it definitely helps me switch off. Yeah. It also kind of inspires me to just think differently and be creative in the law, because I think that's where the real fun is. It's all nice and well to just do the same thing over and over, but actually carving out a creative path to a solution to a problem, I find really, really exciting. And all of the problems that I end up tackling do require that amount of thinking. So yes, I definitely recommend having something outside of the sometimes grim work or reality that this work brings. I absolutely love classical music. Sometimes I think, oh, what would life be if I became a conductor? But I think I'm quite happy where I'm at, and just having going to music is something that relaxes me and brings me joy, rather than something that is my livelihood. Is not a bad way to do it.
Mm-hmm. Well, look, you've been so generous with your time and with the insights that you've given into your work. It's such an interesting area, and I really appreciate you coming on today to discuss that. Honza, it's been a pleasure, and I look forward to following your work and speaking with you again, hopefully at some point.
Thank you so much, Sarah. It's been an absolute pleasure to speak to you today and be part of your program. I love the work that you do, and hopefully our paths will cross again.
Absolutely. Thank you.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.